important that we understand that when people go to court, they tend to bring a lot of evidence. They tend to say a lot of things. They tend to, say a lot of things for them to win, right? But it's the duty of the court to determine who really would win in this case. But let's even look at the issue of the arbitration part. Somebody is saying that I never considered to arbitration. I never, accepted or submitted to arbitration. Submission to that arbitration is something that is fundamental. Once I say that I am not going to submit to the jurisdiction of arbitration, I want to go to court, there's nothing you can do about it. And that's why, when we do Law FM People's Court, we say that the respondent and the complainant must submit, must say that, yes, I want to go through this. But like I said, I never participated in this. So that's something that we should, realize. That's something that we should have at the back of our mind when we look at arbitration issues. It is not like arbitration under customary law is not recognized or under our laws, but the issue that is fundamental is that it should be recognized. So I think I've addressed the issue of when people go to court. This one is saying that I own possession. This one is saying that it was my forefather. Yes, anybody can come to court to claim anything, but it is the responsibility of the court to weigh the evidence, to see the facts, the evidence that has been presented to determine who truly is saying the truth and who truly has the facts and the evidence. One person has testimony on one side, the other has the other on the other side, but the court determines finally who wins. In this case, both the High Court, the Court of Appeal, determined that Leke is entitled, and it's really difficult for the Supreme Court to obtain a decision, two concurrent decisions, not like the High Court gave a decision that was the one way and the Court of Appeal gave the decision that is the other way. Two findings, both from the High Court and the Court of Appeal, saying the same thing, and you want the Supreme Court all of a sudden to upturn them. It's not in all cases. Really, about maybe 20 out of 100 cases that the Supreme Court will just upturn like that. So that's why the Supreme Court, had to rule the way, they did. But finally, what I want to say is, please, let's note at the back of our mind, arbitration, reconciliation, conciliation, these things are recognized in our laws. However, once one person claims that, he was not part of it, that could be a ground, or he was forced, under duress to partake in that procedure, that could be a ground to upturn the decision or discountenance it, in court.